Hi, this is Scott Goddess from Barnes & Thornburg. My one big thing for the Incident Response Forum 2020 is that silent cyber is real. So that means that insurance policies, and not just so-called cyber insurance policies, can provide coverage for data privacy and cybersecurity risks, exactly what we've been talking about all day today. So from business email compromises to data breaches through ransomware, multiple types of insurance policies have been ruled by courts to be able to pay the bills that our clients face. It means that it's worth pursuing coverage under these policies when an event takes place.
Welcome back, and thanks for that extraordinary discussion on the GDPR and the CCPA. The next panel switches things up a little by combining two topics that are sort of related, cyber insurance and class actions, cyber class actions that is, which have both changed a lot since last year. There's been quite a few developments, so we really need to give an update on these two topics. And we have a panel. I'm on this panel this time, but starting, the moderator is Kari Rollins, who is a partner at Sheppard Mullins. And she's always ready for a fight. It's been a lot of fun preparing for this. She's taken one of the less typical paths to an IR career, which is commercial litigation. When her commercial litigation clients kept calling her to represent them in privacy disputes, she began to focus on privacy matters, which in turn led her down the path of incident response. Now she spends her time not just managing litigation, but also counseling companies beforehand, because you learn a lot of lessons when you're doing litigation so they can avoid trouble later on. To me, when your company is hit with a class action after a data breach, which is now pretty much inevitable, everything's going to come down to the motion to dismiss. And in these bet the company situations, Kari Rollins knows how to win. And that's what's so terrific about hearing from her today. Welcome, Kari, and good to know you are A-OK in New York, right?
A-OK here, working from home in New York with views of an empty Union Square, which is a little unnerving, but all good here. Thanks so much, John.
Excellent, excellent. Okay, next we have Scott Goddess, who I think he's been with us. Scott, is this your 5th year?
Every year you run it, yep.
Excellent. So Scott's one of the few today who's done all 5 years. And the reason for that is because in the area of cyber insurance, there's only one lawyer in DC who's risen really above all the others and become the go-to attorney for cyber insurance counseling. And that lawyer is Scott Goddess, a partner in Barnes & Thornburg and co-chair of the Data Security and Privacy Practice Group. If anyone knows sort of which cyber policies work and which not so much, it's Scott. He's the quintessential incident response lawyer because his skill set is vast and he's really fearless. For instance, during this past year, Scott has argued 2 appeals, federal circuit court appeals, on behalf of insured companies against insurance companies who denied charges to his clients. Both in the 11th Circuit. And guess what? To me, he won them both. He won one formally and the other one settled. And I think we all know, though Scott would never admit to this, because of whatever agreements he signed under settlements, that he won the other one. But that's my opinion, and I didn't sign anything, so I can say that, Scott. He handles these cases from start to finish, and that's really something that a lot of people who you've heard speak from today can do. They can really do anything. You didn't see Scott go to his appellant group at his law firm, which he could have done, and say, I need you guys to do this. He took it on himself. So it's great to have you on board, Scott, and congratulations this year on those 2 circuit court victories.
Thanks so much. Well, one secretly and that I didn't talk about.
Exactly.
And one officially.
And then finally, what we needed on this panel more than any was somebody who was a real seasoned litigator to really go back and forth with Kari to make sure we had every perspective covered. And what I like about this panelist, I always admire lawyers like him whose track record is probably the most voluminous of anyone speaking today. That's why Ken Dort of Faegre Drinker, this newly combined firm, was so perfect for this panel because he really gives true meaning to the phrase seasoned litigator. Is very handy to have around during the aftermath of a data security incident when class actions have already been filed. If you look at Ken's bio, it's just a list of pages and pages of cases that he's done with the names of the cases, not sort of a vague reference that we all do because we can't mention our clients. Ken's got a serious track record. And a natural evolution of his litigation experience is to help clients preemptively improve their data security and the protocols again, to make litigation less likely. So you're going to get both of those perspectives from Ken and from Kari. So Ken, I hope things are safe and healthy for you in Chicago. Are you doing okay?
Well, so far so good, but for the fact that I've got 2 college daughters and a high school son under one roof, you know how that can go. But
I've got 2. I know what's going on.
That's right. I
tried to tell mine to slow down the Wi-Fi today so that the conference can go okay. Well, good luck with that.
I've had that discussion too.
All right, let me turn it to Kari, and why don't you get things started?
Great. Thanks so much, John. And thank you to Bruce and our panelists for being here today, especially in these remote conditions. As John mentioned, we are going to be talking about cyber insurance and class action litigation. I think everybody knows by now that data breaches can be very expensive. And one of the first questions I ask my clients when preparing for the inevitable and or when in the midst of an incident is, do you have cyber insurance? And if so, what does that look like? And then what can we do to prepare you to ensure that you can have your claims paid or put your best foot forward to get those claims paid, especially in the event that there has been litigation and you have attorneys' fees that are being incurred to fight that litigation and or potential settlements and or regulatory action. So my first question, I'll start with Scott and let the other panelists join in, but with the breakneck speed at which claims are being submitted, now more than ever, representations made in the application or the renewal process for cyber insurance have been placed under even greater scrutiny. And insurers have been parsing these representations, or in some instances, failures to disclose, in denying coverage for certain claims made under the cyber policies that stem from breaches. So I know you deal a lot with these issues in your practice. What has been your experience with the denial of coverage based on representations or the lack of disclosures in an application or during the renewal process? And what are some best practices companies should employ during that cyber insurance application or renewal process, or pitfalls to avoid?
Sure. So a lot to unpack there. But as a starting point, what I've seen is carriers will not be shy about looking to the application. And if their counsel believe that there's an opportunity to make some hay out of what was in the application, and taking the position that what was in the application was not proper or not true, not correct, or otherwise, they will. And so back as far as 2013, I saw this issue come up. I've seen carriers take the position that if you said that you were certified in a certain way, you met a certain standard or otherwise, and if it turns out that somebody later on says that you were not, then I've even seen carriers question whether you ever were properly certified in the first place. I've seen it in a situation in which somebody made a mistake regarding the number of files or records that were at issue, and the carrier had questions about whether they would have to provide coverage if the representations made were not correct. And there's a case that's been pending in California for a while in which the carrier has denied coverage on the basis of both the application and an exclusion in terms of whether antivirus software, other basically anti-malware softwares were followed and updates were made and things along those lines. And it's fascinating in terms of being on this side of the table, because that case in particular led to a lot of questions about a carrier with which I'd actually had good luck on the cyber insurance front, taking it on the chin as to people saying, well, cyber insurance doesn't pay, and they named that carrier, and they had questions about it. So with that in mind, and keeping in mind that once an insurance company goes to outside counsel's obligation is to represent them. Well, you can question whether it has to be zealous or not anymore under the rules, but they're going to represent them to the fullest extent possible. And so if there's something in an application that wasn't correct, whether it was done with intent or not, the law varies in terms of intent from state to state for rescission of a policy. And that means that your policy goes away, your premium gets returned as if you never bought it. So your follow-up question, Kari, was, what are some best practices? Best practices are, it means more homework for everybody. And what I mean by that is figure out in a best practice who's filling out the application. Is it somebody in Treasury? Is it a risk manager? Is counsel involved? Is the IT department involved? And the final one, which I think is a real best practice and something that I recommend pretty frequently is if the question is unclear to you in terms of does it mean X or does it mean Y, then attach something and say, we don't understand whether you mean X or Y. And so we've interpreted it to mean this. And so this is our explanation, give further detail. If you've received certifications, say, well, we've been certified by this company as, and be thoughtful about how can you explain everything where you have a question mark. And it's unfortunate that the insurance industry, in a handful of times of which I'm aware, have put policyholders in this box. But as they become more stringent and more reliant upon outside counsel to help them with claims, then it's a best practice to be mindful of how things could be used against the policyholder. And one final point, I know I gave a very long answer to a pretty simple question, is that when you read an insurance policy and it says that the application is attached and becomes part of the policy, from my perspective, carriers probably are doing that in an effort to take advantage of those states that have said when the application is attached, it can be used more readily for rescission, which is pretty terrible in terms of thinking about yourselves having a business partnership with your carrier. But here we are.
Scott, I have let me ask one question. Just having, litigated these situations and handled, God knows how many, breach responses, it just appears to me, given, and I've got a pretty good sampling, but I like your opinion. Over the years, it seems like the relationships between insureds and carriers has deteriorated a little bit. And I won't say become adversarial, but they seem to be a little bit more looking at each other kind of, askance. I mean, is that kind of your view too, or because I think a lot of people will be interested to know whether this is just me and my carrier, or is this happening across the board?
It's happening more regularly, and I certainly open it up to Kari and to John in terms of what you're seeing. But what I've seen is that insurance carriers are becoming more reliant upon outside counsel to quote unquote adjust the claim. Well, why is that? If your insurance policy is clear and easily understandable by the reasonable business person, why do you need a lawyer to handle a claim that's supposed to be done in the ordinary course of an insurance company's business? And if you're the lawyer that's adjusting the claim and helping with the investigation, are you doing so with a mindset of, I want to protect everything because it might be discoverable? Are you doing everything with a mindset of, this is my client and I have to be an advocate for them? Or are you handling it in a way where you're adjusting it with keeping the insurance company's interests at the same level as the policyholders? And as a lawyer, how do you do that in terms of the rules of ethics when you're being hired as outside counsel? And I've dealt with multiple clients where when they go to their carrier and the first response or the second phone call involves outside counsel, they immediately have the reaction of, well, hang on a second. Why is outside counsel helping my carrier? I thought we're supposed to be aligned here, that we're supposed to have the same exact interest. Why do they need their own lawyers to tell me where the coverage is? And is this lawyer really going to be spending her efforts to find more coverage rather than less for me?
I think in my experience, I've seen the same where outside counsel for the insurer gets involved in questions relating to claims coverage much earlier on than would have been normal course prior to my data breach experience when you're dealing with regular D&O insurance claims, for example. So, but I think that raises a good point. When it sounds like from your advice and consistent with my own best practices for the application process is that it's a team effort. You need to have the right heads looking at the application policy and scrutinizing the policy. And it may be, just as much as you have an outside counsel coming in for the insurer looking and scrutinizing the policy on the back end, you may want counsel in-house or outside or other experts like John and his team coming in and scrutinizing the representations you're making in your application with respect to your cybersecurity posture, the reasonableness of your standards, the measures and tools that you're not making overstatements or overpromises or absolutes that can come back to bite you when you do have that coverage counsel engaged by the insurer on the back end scrutinizing that policy.
Kari, I'd be curious as to what each of you do in these kinds of situations, because one situation is that I had recently where I get on the phone with the insurer to talk about the claim, and they have a top flight litigation firm on the call who the next day dumps a 25-page, looks like a document request. It is a document request because this person's a litigator, and it covers the application process, all your cybersecurity back then. It wants every email pertaining to any kind of cyber you've had. It wants all the reports and everything having to do with the breach. And it's going to cost your client, $250,000 at least to respond to it. So, I think the first thing I do in that situation is, call one of the three of you guys, because you can't handle that kind of, imagine you crash your car and Geico calls you and sends over Williams and Connolly with the adjuster. It's disgraceful. So you guys probably all, I guess we could talk about this for hours, but maybe in less than 30 seconds, each of you could tell people what to do in that situation, because I think it's pretty common.
Well, one of the things that we've done, or to anticipate that issue and to avoid the kind of, let's say, potential conflict between acting as a panel counsel and acting as a true separate, non-beholden attorney relating to the insurance company, would be that, and this probably would apply to more of our larger clients, is that when they're negotiating their cyber insurance, they're creating their own panel counsel, basically, which is us, and laying that all out so that in the event of a water landing, they're bringing us in. And of course, we've made adjustments for the rates and all of that, but there's no question who we're, let's say, beholden to. That might be a little bit too strong a word, but we're representing our client, and we're not concerned about how our acts will affect the insurance company.
I think, Ken, we've had the same experience too in that regard. But I think the other big takeaway, and hopefully the takeaway from our panel today, is preparedness. It's important to know, even as you're going through the application process, but even well before you have a data incident, what are your policies? What do your policies say from a cybersecurity standpoint, a written information security incident response standpoint? And are you actually practicing what you're preaching in those policies? How do you audit? What paper documentation do you have regarding training, so that when you start the application process, and or have to answer and respond to document requests that you may get from insurers in the post-incident claims environment, where the documents are, the statements that you've made are tested against your own documentation, and you're able to provide sort of non-privileged support for the security posture and your response to the incident consistent with what you represented to the insurer prior to that claim.
That's a good point, because, not only is it important for purposes of the insurance application process, but that's important for purposes of just good cyber IT safety practices at all. Because, is that we've done through, over the years, you could draft the actual quote unquote perfect cyber access, cybersecurity policy. And if it just goes in a drawer, it's meaningless. And so, that carries a lot of weight, both practically as well as in the specific insurance context that we're talking about.
And I have a really great question on this subject that I think we should direct maybe to Scott too, since he was just getting ready to speak. But lots of great questions coming in, actually. And somebody asks, typically, is there an opportunity to update the application information upon renewal or prior thereto? If something changes during the term, should there be a proactive communication to the insurer to update?
So in terms of that, if there are changes in the information, particularly if there are changes in terms of the size of the company or subsidiaries or otherwise, then, and certainly if there's a renewal application in process, the carriers will always take the position, see how I always frame it as what they want. The carriers will always take the position that they need more information, that they need to know these certain things. And perhaps they do, perhaps they don't. They've never been willing to share with me the underwriting information to suggest that it's necessary, but set that aside. Sometimes I can't help myself. If there's information that does make a change in terms of your application, then the carriers will certainly hope that you would provide it to them. And let me say this as another aside. I typically don't see cases where everything's going great. People typically don't come to me and say, hey, Scott, listen, we want to hire you. We're happy to pay your rate. Everything's going great, but we want to pay you several $100s per hour to just hang out and watch what's going on. I think it's worth our while. It's usually when something's gone sideways. So for all the ones that I see, I'm sure there are hundreds and thousands of claims that are handled just fine or close enough for horseshoes and hand grenades. So in terms of back to the question, what should you tell them and should you disclose it? Carriers will always welcome more information in my experience. And so if there are details that show a change in terms of the risk or otherwise, I would be surprised if they said, please don't tell us. They always take the position that they need more information to do whatever they're doing.
Related to another question, and this sort of dovetails into something we were talking about the other day when we met, was hiring a specialist to assess sort of your risk levels and the coverage and your coverage needs. And I think part and parcel of that is a question that one of our audience members had about how companies with their policies navigate hiring their own incident response consultant or counsel versus relying on the panel counsel or the panel vendor that's in the policy that they're currently evaluating or applying for. So and I'll turn that over to anybody who wants to respond.
So I can take on a little bit, and it falls upon what Ken and Kari, you both were saying, is that in a perfect world, you'll have addressed that at the time that you're buying the policy. So if you're a client of Kenneth or Kari's and you love working with them and you're buying a policy from a carrier that does not list them in the policy, ask them at the time that you're purchasing or renewing, can I add them? And address the rates that will be paid. Those are in a lot of policies. Some carriers are more stringent upon using their team than others. And that's part of the analysis. There's one middle market carrier that has its preferred vendors for everything. And and they love to stick with that team of preferred vendors. And then if your question is, well, do I go with the lawyers that I know or do I go with the panel lawyers? The lawyers that get referrals that are in the policies that are on panel see a huge amount of volume. And so they have a ton of experience and they're excellent lawyers. And if you have your own lawyers that you work with that you know, then your lawyers are already a step ahead in terms of understanding the business or otherwise. And so you get that one weird spot where maybe you're a company in which you do not have outside counsel with this experience and you're trying to weigh, do I have my counsel get up to speed or do I go with a panel firm? I've had clients where they've engaged the panel firm and they actually been thrilled. They said, wow, they didn't know anything about us before we got started, but they know this area inside and out. And others say, no, listen, I've got this firm that I've been using for 50 years and they've been a business partner with us forever and a day, and I want to use them. And so your best case scenario is talk with the insurance carrier as you're purchasing, have them be at it.
Yeah, I go back and forth on this all the time, Kari, because I think sometimes the forensics firms on the panel are terrific and they've lowered their rates so that because they're getting bulk work from that particular carrier, which kind of everybody wins in that situation and things can work. But other times I had a ransomware case recently where they called me sort of after the fact. And I think the insurance company really muscled this big manufacturer because they didn't have their own, believe it or not, even though they were a publicly traded company, they didn't have their own GC. They had never experienced this before like everyone else. And they got really some bad advice. So in a ransomware situation, you're getting really intense advice, maybe to pay the ransomware. You're going to have to go out and use a separate firm to buy the Bitcoin. The insurance company has to reimburse them for the Bitcoin. They have to be satisfied that transaction actually happens. Think about it. It's insanity. But 99% of the time, maybe that's too much of an exaggeration, but a very high percentage of the time, people pay the ransom. And that's because the insurance company is behind them, willing to make that payment. So what I've seen is a bit of a deterioration because I've seen the insurance carriers are suddenly getting swamped with this stuff and suddenly saying, okay, no forensic investigation, let's just pay the ransom, for example, which is a really bad situation. And then you don't have people who have any knowledge of forensics or any knowledge of law enforcement So I really go back and forth. And I guess the answer is there are good firms and bad firms. But I will say in the forensic space, there's very few good firms. So you really, if you talk to somebody in the space that you trust and just say who's good and who's not, it's an area where there's like over 3 million job vacancies of cybersecurity. So it's still growing.
I would agree with that because, the one other thing that we're talking about, there's really two components to the representation, in a breach circumstance. One is just the true expertise. You know what T's to cross and I's to dot. But, for a smaller, medium-sized to smaller enterprise, the representation involves a lot more than just knowing what the law is and what the requirements are. There's a lot of hand-holding. There's a lot of counseling because this is probably maybe their first breach and
right.
they're shook. And if they're in a relatively competitive field, they're worried about maintaining their business and they really want someone who they trust and who they can talk to in addition to knowing what they need to do from a legal perspective. And
Kari, how does that play into the class action work that you do with the insurance? Is it the same sort of balance that you have to make? Because it all comes down to that motion to dismiss, right?
Sure. From the class action litigation perspective, if your client has notified the insurer of a data breach and then litigation ensues therefrom, then you are their litigation counsel. You have to keep the insurers, usually it's their outside counsel, up to date about the litigation. You have to provide, and it's important to provide them with cost estimates. What are the attorney's fees going to cost? And a lot of times the insurers will ask for very specific breakdowns, like what will it cost? What can you estimate for the motion to dismiss? How much is going to cost to brief that? How much is it going to cost to brief class certification? How much is it going to cost to engage in interim discovery between those 2 points? And it's important for the benefit of your clients to keep your insurer's outside counsel informed and up to date about the litigation, and keeping them abreast of, look, we intend to file this motion to dismiss. Here are the arguments that we're making. But you also at the same time have to be cognizant of issues of privilege and your own communications with your client. So it's certainly a fine dance and a fine balance because you want to be cognizant of privilege, but also provide the insurer's outside counsel to give them enough information so that they can make informed decisions about the litigation rather than pushing you into settlement too early, too often, before the leverage points in class action litigation can be exhausted. Those leverage points being, the motions to dismiss phasing, and also if you make it past that point, class certification briefing if you're dealing with a class action litigation, which I know Ken has a lot of experience in and may offer some additional insights.
Sure. Basically, to follow up with that, I have a tendency, having done this long enough, that, the class action litigation is almost kind of like the end of the game. And it's an episode that started possibly years before. When the company was first setting up its cyber structure, and you're setting that up for purposes of making the company look as good as possible down the road in the event of a water landing. And there are a variety of water landings. The first one would be the breach itself. Hopefully you've got systems in place that minimize the risk of that. But that's all you can do is minimize, not eliminate. And then once you're involved in a breach response and you're doing notification and you're dealing with regulators and or AGs, you've got to make sure that you're complying with the law, but you got to make sure that everything that you're saying, everything that you're representing, even in the notification letters, you got to be clear that what is that going to look like down the road in the event of potential, litigation. And then obviously once litigation occurs, you've got this entire bandwidth of material that, you're now stuck with. And you've been preparing it, not necessarily for purposes of defense work, but you want to keep yourself in as good a position as possible, if that happens.
So that actually pivots into a great question for Scott about in this day and age, a number of different types of litigation can ensue from a data breach. One of those types is insurance-related litigation. And so, Scott, if insurance coverage is denied, and I know you've had some experience with this, is that the end of the game then? Should companies take no for an answer? And what's been your experience with some of the, and this is sort of another question from an audience member, what are some of the coverage issues or claims issues that you're seeing crop up in insurance litigation today around cyber insurance policies?
Sure. So taking no for an answer plays into the insurance industry's reputation for delay, deny, defer, etc. So there are so many insurance cases on the books. And what that means is that each one of them started out with the insurance company saying no. And there's not always a victory for the policyholder, but there are a lot. And there's a lot of good case law that always started with the insurance company saying no. And so then it's a question of how much basically is the matter worth and how much is the policyholder or insured willing to invest in terms of going after what they thought they were getting. And sometimes they have no choice. Sometimes if the claim is worth enough, then they're forced to litigate. Sometimes insurance carriers sue policyholders. Happens pretty frequently. I've been in the spot where insurance carriers will run into court and file declaratory judgment in an effort to get a ruling that there's no coverage. It's not even though the policyholder was the aggressive one there. It's the carrier runs into court to get the court of their choice and then to basically also fire a shot across the bow at the policyholder thinking, you think this is going to work, we're not going to let you. And so then the next part of that question is, where are the coverage disputes and what's giving rise to fights? There are things that have evolved over time. And so some of the earlier disputes were questions about coverage after a PCI event. So when the processor comes in and operates on behalf of the brands and says, well, you're responsible for the following millions of dollars of fraudulent charges that resulted because of the breach on your system, and you're responsible for the millions of dollars of card replacement costs you've been assessed, then they take that money from you by setting up a reserve account. How does your cyber insurance cover? And some carriers said, we don't cover it at all. There are exclusions. That was one of the first cyber insurance cases I worked on in 2008, 2009. Some carriers say, well, you only get 10% of the limits for that. And I've fought about that in court. And some carriers, if they write it appropriately, now say it's covered in full. Some carriers have said, well, this matter arose prior to so-called retroactive date, basically a date that they pick where they're saying any event that happens before this date, we won't cover it, even if the claim is made during the policy period. Some carriers say that the only policy that could possibly cover is cyber insurance, not general liability, not crime, not otherwise. And there's been a lot of litigation on that front. So, and then the last thing, what I'm seeing on cyber insurance is when the claims are bubbling up and are different from what the industry has seen in the past. I've seen an unfortunate reaction amongst personnel that represent carriers saying, well, that's not what we meant to cover. That's not what the policy was designed for. That's not what we wanted to cover. And I said, well, hang on a second. I thought we had a contract and the language controls. That's what you always tell me when it's convenient for you to cite an exclusion. Now, all of a sudden, we're talking conceptually what you wanted to or meant to cover. And so I find that there can be confusion amongst the lawyers and perhaps the underwriters saying, well, we didn't even know this kind of claim existed. So when I hear that's not what we meant to cover, I usually translate to mean we never thought about this kind of claim. And so we didn't envision it. And now they're forced to turn to the language. And so that invariably leads to disputes, because if the underwriters have the belief that they didn't mean to cover it, AKA we didn't think about this, then their outside counsel is extraordinarily stringent in terms of how they'll apply the policy language.
And I think that's indicative of this larger area of surrounding data breach litigation is oftentimes because this area of law is constantly evolving and data breaches themselves are constantly evolving and the facts are constantly evolving. You can't foresee or predict the future. And so you have to adjust and respond. And to that point, Ken, for companies who need to be prepared for the inevitability of a data breach, but potential litigation that could ensue, what are the types of lawsuits, class action or otherwise, that you see could be generated from a single data breach today? Because I know there are myriad.
Oh, sure. I mean, the one that obviously comes to mind are consumer class actions. Those are the people whose data was obtained and whatever. And those could be customers. This could be credit card customers, and morphing into PCI litigation brought by the card companies, who are going to be handling a lot of the losses in the event that there is identity theft. There are financial related, or there are shareholder derivative actions for drops in the stock price based on allegedly false statements made about the level of security of the company. I mean, there are obviously then just regulatory investigations, FTC, the SEC, various state AGs, coming at them, from a civil perspective and a criminal perspective with respect to, unfair trade practice acts, consumer fraud claims, at the state levels. So you've got literally, and it's just growing. And obviously the 800-pound gorilla coming out of the closet, if you will, is CCPA claims. I mean, those are, probably just starting now. There's been a few that have been referenced, but obviously the law didn't come into effect until beginning of January. So breaches that occurred before then are kind of off limits. But with the general reasonable security standard that it imposes on top of the personal cause of action that it pulls in from the breach notification statute, it opens the door pretty wide, going down the road. And as the other states are beginning to come online with their own versions of CCPA, that's just going to get even bigger.
It's Kari, I was going to ask you the question, because if you take the Marriott class actions, right, where there were 5 tracks, I think it's just such an incredible maze to navigate. And I'm not going to be critical of the Marriott team that worked on this, but if you look at it, they attached the PFI report to the securities class action response to the motion to dismiss. So what's a PFI report? Well, just in short, during a PCI data breach involving retail, they have to come in and get this technological rectal exam done by a PFI firm that they have to pay for themselves right after the breach, because the brands want to know, hey, who were you responsible for this, or did we do, or was it just one of those things? And so that's a report that obviously is a roadmap if there's any issues, and there's no attachment like response from the company, and the company might have an entirely different view. So in Marriott, they attached that on one of the tracks, and then on another track, they said, on the securities track, they said, hey, we want to see that. So they attached it, I think it was on the governmental track or the consumer track. The securities track said, the plaintiff said, hey, we want to see that. The defendant said, no, you can't see it because of the Private Securities Litigation Reform Act. You're not allowed to conduct any discovery. Well, the judge said, no, I don't think so. You can see this report and see it now. It's just one report. It's easy to produce. And more importantly, the public has a right to know what happened in this document. So all of a sudden, you're on this MDL track in Marriott, and the plaintiff's attorney has got the PFI report, which is money in the bank, I would guess. So I think, Kari, how do you stop that from happening?
Sure. And I don't know that you can stop it from happening. I think the PFI report is going to be a report that is, if a credit card breach was involved, is a report that is always going to be sought after by regulatory authorities, plaintiffs' firms, and any other opposing counsel, to the extent you're disputing the nature and extent of the practices of the company who got breached. The importance to understand about the PFI report is that it's crafted for a very specific purpose, and it is highly confidential. So you want to be thoughtful in how it is produced in the litigation to ensure that there are the appropriate security protections around that report, which provides effectively a roadmap of the company's network systems and security itself. But I think what your question led to, in my mind, is a larger issue. A lot of these cases today are filed simultaneously, whether you're in litigation with an insurer and you have litigation that still is continuing or proceeding from consumer class actions, financial institution class actions, shareholder class actions. You have to be mindful of the competing interests in the different cases, and that one statement in one case could be used against you in another case. So it's important, if you're not using the same counsel, to have coordinating counsel. And as societies and cultures in other countries are getting more litigious, I'm experiencing now in another case where Canadian litigation was filed very shortly after consumer class litigation in the US and is proceeding on a much faster track. You want to be mindful of what you're saying in that forum with your local counsel or your Canadian local counsel there, so that it doesn't come back to bite you in the US litigation where there might be different standards at play. And so again, it's all echoes back to being thoughtful in what you're saying about your security practices and your response to the data breach and how you're characterizing the data breach, and how you're managing the litigation. But I did want to ask one, we've gotten so many questions and I'm sorry we can't get to all of them, but there was one related to CCPA, and it sort of dovetails off of what Ken was talking about at the end. And this is a good question for both Ken and Scott, and John, is, when CCPA first came out, before its final effective form, there was private litigation or private right of action attached to general privacy violations, separate and apart from the breach notification violations, which have always had a private right of action. And I know at that point in time, with the statutory damages attached, insurers were really worried that this could turn into your traditional TCPA litigation, right? And we're concerned about whether CCPA claims may be or should be excluded from coverage because the potential liability was so great. But now with that private right of action for those, privacy violations gone, and the private right of action attaching still only to data breach notification, what are you hearing, Scott, about whether CCPA claims may go the route of TCPA claims and be excluded, or will we still see coverage for CCPA-related violations or claims, even if not pursued under CCPA itself?
Wouldn't that be the best? The thing you need the most insurance for, you get the least. So I have not heard the industry yet trying to exclude CCPA. And TCPA, we know that the industry made efforts to exclude it. Not every policy does, and some policies do not have an exclusion. Some policies cover defense costs. For CCPA, I've seen efforts where carriers are actually affirmatively writing coverage in for it along with GDPR. So I certainly would hope that as policyholders need this coverage, and cyber insurance is designed for cybersecurity and privacy events, that the largest statutory U.S. source of privacy liability would be covered. But I don't get to write the policies. I just get to argue about what they mean.
So I think we just have a couple more minutes, and we've got some really great questions in here. And I apologize that we won't be able to get to all of these. But one
Kari,
which I
we'll get all those questions sent to us afterwards, and you guys can answer them and as much as you want. Go ahead. I'm sorry.
Great.
Perfect. Well, then what I think I'll do instead is, with the few minutes that we have, giving each sort of John maybe 30 seconds, Ken maybe 30 seconds, and Scott 30 seconds. Sort of if you had to provide one piece of advice based on your work and experience to our listeners today, whether it's about preparedness for litigation, preparedness for the cyber insurance process, or just the forensic process from John's point of view, what would that be? And let's start with John.
Well, you know what I recommend? It's really not in forensics, and I've done this for many, many clients, is I literally, if you're putting a policy together, and this might sound somewhat self-serving for Scott, but I tell them to hire Scott and pay him whatever to go over the policy and do a reverse gap analysis. Just tell me, because you just talked about all that class action. How on earth is any insurance company going to pay for something like the Marriott MDL, where you've got 5 tracks, coordinating counsel, different counsel on each, top flight firms working everywhere? You've got to be prepared, and you really have to do a reverse gap analysis. You got to look at the kind of breach that you're going to experience, right? Whether you're PCI, whether you're healthcare, whether you're financial. And here are going to be where my biggest expenses are going to be. We know there's going to be notification. We know there's going to be credit monitoring. That's easy. But is my malware reverse engineering going to cost more? Am I going to have to hire 5 lawyers? Am I going to have to get 5,000 new laptops? That's how I would do it.
Yeah. Great.
Yeah, I mean, I think as I said earlier, class action defense work is really grounded in how you handled the actual breach remediation and notification, which is itself grounded in your proactive cyber policies and your cyber just security work. And I think if you keep all of those different aspects in mind, you can create an overall environment at your company which is responsive to each one of those considerations. God forbid you move into one stage after the other, but I think you need to kind of keep a holistic approach to this and not focus on one to the exclusion of the others until you're in a reactive mode. You have to remain proactive, I think, at all times, and I think that'll help you when you are in a more reactive, more crisis situation.
So my quick take, because I think we're just about out of time, is when you learn of the event, go to your carrier right away, let your carrier know right away, and give them the information that they're asking about. Because the more that a carrier views you as treating them like a bank account for which you're seeking them to write a check as opposed to a business partner, the more difficult your life will be with them. Great.
So treat cyber insurance and litigation proactively and not as an afterthought. I think that's our biggest takeaway here. Preparedness.
Kari, thank you so much. And Scott, John, Ken, terrific job. Our last panel is on financial regulators, cybersecurity, and data breaches. We will kick that off at 4:15. Thanks again. We'll be right back.